appreciate it. So as Kathy mentioned, we're going to go through these topics today. I'm going to give a little general background on software patents, and then we'll jump right into Alice Corp, the Supreme Court case from last June. And then we'll talk about DDR Holdings, which is a Federal Circuit case from last December. And then Blaine will go over some guidelines and examples from the USPTO. And then we'll discuss some practical implications of everything that we've discussed. So the foundation of everything that we're talking about today is 35 U.S.C. 101, which is the patent eligibility portion of the patent statute. And hopefully most of you have seen this. I'm not going to read it, but this is the patent eligibility statute, and what's excluded, which is important for our discussion today, are abstract ideas, laws of nature, algorithms, and we'll talk a little bit more about what's excluded from patent eligibility a little bit later. So software patents. Software patents can cover systems of computers, for example, computers that are connected to one another and transfer information back and forth from one another. They also can cover methods of doing computers doing things. They can cover different computing devices and combinations of the above three things. So our first example here of a software patent is for, as many of you can probably recognize, we'll start in the upper left-hand corner. This patent is US patent number 7,657,849, and it's to Apple's slide to unlock functionality of the iPhone. And as you can see, starting at figure 5A, there is software behind this functionality of the iPhone device that allows a user to swipe with their finger, moving down to 5B, to unlock this touch screen, and then you can type in your code to access your iPhone. Again, there's software underneath this functionality that allows this device to function as shown in these figures. Next example is US patent number 8355686. It's to a radio preset key assignment method and apparatus, and this one is owned by SiriusXM. And you can see there are different tuning processors and key assigners, and the functionality of these processors that allows a user to set some presets for example, tuner 1 and tuner 2. There's software underlying in the functionality of these processors. So those are two basic examples of software patents and mechanisms that are, show an underlying of software functionality. So now we'll move into Alice Corp, the Supreme Court case from last June. Now, in this case, the claims at issue were drawn to, as the Supreme Court held, an abstract idea of intermediated settlement where there was a computer system, and the computer system was used as a third-party intermediary to mitigate settlement risk between two different parties. With the Supreme Court, one of the main points of the case was merely requiring a generic computer implementation fails to transform an abstract idea into a patent-eligible invention. Now, the Supreme Court recognized that per Section 101, claims directed to laws of nature, natural phenomena, and abstract ideas are not patent-eligible based on a policy of avoiding preemption of the basic tools of scientific and technological work. But in order to avoid rigid application of this rule, the Supreme Court recognized that an invention is not rendered ineligible simply for involving an abstract concept. The Supreme Court also recognized that you must distinguish between patents that claim the building blocks of human ingenuity only and those that integrate these building blocks with something more. And that's a key phrase that we'll be touching on a lot today, is something more, thereby transforming patents that simply only contain an abstract idea into a patent-eligible invention. In order to do that, the Supreme Court set forth a two-pronged framework. And the first prong is you need to determine whether the claims at issue are directed to a patent-ineligible concept, such as an abstract idea. And if so, if yes, move to prong 2, which is examine the elements of the claims at issue to determine whether the claim contains that something more, those additional features, or, quote, an inventive concept to transform the nature of the claim into a patent-eligible application of an abstract idea. So prong 1. Examples of an abstract idea are mathematical algorithms, including those executed on a generic computer, fundamental long prevalent practices, such as any economic and conventional business practices that you don't need a computer for, some practices that have been done for ages. Also, meal planning is an example, and game management is also another example of an abstract idea. Now, prong 2. Prong 2, again, is the prong that you look to if the court has determined that the claims are directed to an abstract idea. Does the claim language, the elements of the claims, add something more to make the claim patent eligible? So the court discussed you must be something more than merely reciting generic computer components. Also, something more than requiring a generic computer to perform generic computer functions, such as using a computer to obtain data or rapid processing, for example. Those typical generic computer functions that anyone would use a computer for does not add something more to a claim. Further, something more could be shown by claims that purport to improve the functioning of the computer itself or affect an improvement in any other technology field. So what does this all mean? Well, many courts have recognized that distinguishing between claims that recite a patent-eligible invention on the one hand and claims that add too little to a patent-ineligible abstract concept can be difficult, as the line separated two is not always clear. Well, I think all of us could have figured that out by now, but the courts are recognizing that as well. So now we move on to DDR holdings, and you'll recognize the reason why we've included this case, but I'll tell you right up front that this is the only Federal Circuit case post-Alice, meaning post last June 2014, that's held the computer software claims that were at issue are patent eligible. In this case, decision came down last December. So the problem addressed by the patent at issue is the following. Retaining website visitors that, if adhering to the routine conventional functioning of the internet hyperlink protocol, would be instantly transported away from a host website after clicking on an advertisement. So we've all seen this. You've been to a website before that have, excuse me, they'll have advertisements either on the side of the web page or embedded right in the web page itself, where you click on the ad and you're taken away from the primary website. Well, these folks here, the defendant had a product that, as we'll see, addressed this problem and hopefully keeping their customers on their website while at the same time allowing them to click on the advertisement. So the solution is, upon clicking on an the solution offered by the patent claims was, upon clicking on an advertisement, the website visitors were no longer transported away from the host's website. How did they do this? Well, they had an outsourced provider that directed the visitor to an automatically generated hybrid web page that combined the visual look and feel elements of the host website and offered the product information from the third-party merchant's website related to the clicked advertisement. So rather than instantly losing visitors to the third-party website, the host website provider instead sent the visitors to a web page on an outsourced provider server that actually provided these visitors with what they were looking for, in other words, the third-party merchant's products, but the visitors did not actually enter the merchant's website. They were held at the host website. So the Federal Circuit applied the two-prong framework. Prong one, are the claims of the 399 patent directed to an abstract idea? Again, if so, if yes, do the claims add something more sufficient to transform the nature of the claim into a patent-eligible application of that abstract idea? So the court held that there was no, in terms of prong one, is there an abstract idea in this claim? Well, there is no recitation of a mathematical algorithm, and there's no recitation of a fundamental economic or long-standing commercial practice. The court noted that the claims address a business challenge, which was, again, retaining website visitors. But it's a challenge particular to the Internet, which will become important in the court's holding. However, the court here ultimately punted in answering step one and moved right to step two, which was held to be met. The court noted that the claims at issue stand apart from previous cases. Okay, why? What's important here? And this is what, again, what we'll be hitting on later. Do the claims in this case do not merely recite the performance of some business practice known from the pre-internet world, along with the requirement to perform it on the Internet. That's key. Instead, the claim solution is necessarily rooted in computer technology in order to overcome a problem specifically rising in the realm of computer networks. Further, these claims do not attempt to preempt every application of the idea of increasing sales by making two web pages look the same. Rather, they recite a specific way to automate the creation of a composite web page. And in doing so, the claims of the patent solve a problem faced by websites on the Internet. So there are a couple things going on here. There is a lack of preemption, which is very important in terms of allowing claims. Again, looking back at what the Supreme Court said in Alice, that was something that the court and the reason why Section 101 was drafted, so as to not preempt laws of nature and abstract ideas. So as a result, the 399 patent claims include additional features that ensure the claims are more than a drafting effort designed to monopolize the abstract idea. In short, the court held the claim solution amounts to an inventive concept for resolving this particular Internet-centric problem. That's the second part here, rendering the claims patent eligible. So not only do these claims not preempt the use of an abstract idea, but these claims are directed to a particular Internet-centric problem. So those are the two real main points of this case. So other cases post-Alice, as you can see, here's DDR, and the blue represents courts holding that the claims are valid under 101, and you can see total equals 26, and claims rendered invalid under 101 by courts in the PTAB total 153. Now again, DDR is this little guy over here, just one out of the Federal Circuit versus 7. Out of the district courts, you can see 12 were held to be valid as opposed to 39 invalid. And the PTAB, these are probably appeals of final office actions where we have only 13 claims rendered valid, 13 cases where claims are rendered valid, whereas 107, the PTO is really killing us here, where claims are rendered invalid.
Okay, so I want to talk a little bit about the examiner guidelines that were issued by the PTO in December 2014. These were prepared by the PTO to help examiners as they are evaluating patent applications under 101. The interim guidelines contained a flowchart that was meant to help examiners review the claims under 101. and it had a multi-step test. You'll recall from earlier we were looking at the two prongs of the ALICE application, the ALICE framework, and here we have the two prongs, although they've broken it up into step 1 and step 2A and 2B. So we're going to break this down a little bit and look at this flow chart, because this is how examiners will be looking at the claims of a patent application that you may submit or you may consider submitting. So what we've traditionally been referring to as prong or step 1 is what they refer to as step 2A in the flow chart. And that is determining whether the claim is directed to a law of nature, natural phenomenon, or abstract idea. Generally, claims are not upheld based on them not being directed to a law of nature. In other words, it's very easy to identify an abstract idea to which a claim is directed. In most, for example, office actions that are rejecting claims under 101, the examiner is reciting a very broad abstract idea and asserting that the claim is directed to that abstract idea. So this is the most common route that's being seen in 101 rejections, at least in examination. So if the claim is not directed to a law of nature, then we don't proceed to the next step. It's a no. The answer to this question is no, and therefore the claim qualifies as eligible subject matter under 101. So presumably, if you do not receive a 101 rejection for an application, then presumably you're presumably meeting this, either this or the next step. So if the examiner determines that your claim is in fact directed to a law of nature or an abstract idea, then we proceed to the next. So the question is, what does directed to mean? This is an example of one of the slides from the PTO's slide deck that was used to educate examiners about the use of the guidelines. So this slide deck is available online, and it provides some insight into what the PTO means when it uses the words directed to. And in fact, it means that the exception is recited in the claim. In other words, that the claim sets forth or describes the exception. Now, I wouldn't say that this is too helpful, but they do note that if the claim recites an exception, but when the claim, when viewed as a whole, does not seek to tie up the exception, then it may not be, in fact, directed to an abstract idea. So if the if the PTO examiner determines that, in fact, the claim is directed to an abstract idea, then it would proceed to the next step. Now, if the exception is merely mentioned or referred to in the claim, then likely it is not directed to that exception. So for example, in this slide they have a teeter-totter comprising an elongated member. Now of course, a teeter-totter involves several laws of physics, including levers, fulcrums, and so on. But the claim is not reciting these laws of nature, these abstract idea, and therefore the claim is not directed to the abstract idea. So if the examiner were to find that your claim is directed to a law of nature or an abstract idea, then it proceeds to the next step. Now that's what we've been referring to as prong 2. They call it step 2B. And that's whether the claim recites elements that amount to, quote, significantly more than the abstract idea. And as part of that test, it can either qualify as eligible subject matter under 101 if the claim adds something more, or it will not qualify if the examiner determines that the claim as a whole does not amount to significantly more. Now, importantly, in either case, the examiner is directed to continue on to sections 112, 102, 103. So it's important to remember, of course, that 101 is just one step, one hurdle to get over, and there's still all the other sections of the Patent Act to satisfy. The question is, what does significantly more mean? And this is really where the majority of the battles are being fought under 101 at the current time. So the slide deck for examiners provided some specific examples of what qualifies as significantly more. For example, improvements to another technology or technical field. It's not really clear what that means. Improvements to the functioning of the computer itself. This one has been pretty clear since Alice, as it was mentioned directly in the Alice case. And that's anything that is somehow improving the memory, the speed, and anything that improves the functioning of the computer itself would be something that's considered significantly more. Whether or not the claim is applying the abstract idea by use of a particular machine, whether there is a transformation or a reduction of an article to a different state or thing. So there's a number of different ways that something more can be added to the abstract idea to make the claim patent eligible. These are just a few of the examples. And to further clarify, the PTO in January of this year provided several examples to not only examiners, but to those who were drafting patents. And in part one of the examples, there were four sets of claims where the claims were patent eligible. In part two of the examples document provided by the PTO, there were four sets of claims where the claims in question were patent ineligible. And each of the examples had lengthy text showing how the claims should be analyzed under the guidelines, the 2014 guidelines that were provided. So the examples were essentially a way for examiners to see claims in action, along with a lengthy and detailed analysis of how the PTO believed the outcome of the Alice framework should apply to each of the sets of claims. Now, I wanted to provide just one example of the claims from the particular example set. Now, this is an example of a claim that was ultimately determined in the examples document as being patent eligible. What you can see is that it is a computer-implemented method, and it's essentially adjusting a grayscale image. You don't need to go through the steps necessarily, but the document noted that, in fact, the step of generating a blue noise mask was an abstract idea. So the examples document said, well, because prong one of the Alice framework has been met here, it needs to proceed to the next step. There needs to be something more added to the claims in order to make this claim patent eligible. However, in this case, the examples document noted that the claims actually involve a generic computer. If we go back to the claim in question, what we see is if we highlight the steps or the elements involving a computer, what we know is they're extremely generic. It's a computer-implemented method. It's generating with a processor. It involves a first memory location, second memory location. There's a comparing step of the processor. So based on this, it looks as if almost any computer could perform this operation with the proper software. Well, if that's the case, a general purpose computer does not transform an abstract idea into a patentable invention. And here, this was such a high level or generic computer that it certainly would not transform this into a patent eligible invention. However, the examples document noted that in fact several steps actually saved the claim because it ended up that they provided something more. And it was the comparing and the converting steps at the end of the claim. Essentially, the examples document noted that these steps actually improved the functioning of the computer itself. In other words, the computer used less memory, it ran faster, and it produced a better image as a result of these two steps. Now, how did it know that? Well, that information, the examples document said, was taken directly from the specification. And so this is a point where I want to emphasize it will be a good idea to put in the specification of any new patent application, for example, support for the something more prong. If you want to be able to point to some aspect of your invention as providing the something more in your claims, then you're going to want to provide that support in the specification. That will either prevent a one-on-one rejection in the first place, or it'll provide you support for arguing against a one-on-one rejection in the future. So this particular example was of a patent-eligible claim. And the examples are very helpful for determining how the Patent Office looks at different types of claims. Now, the weakest point for attack, I believe, is to argue that the claim recites significantly more or the something more than the abstract idea. It's very difficult to argue against the examiner's identification of an abstract idea. Once the examiner has decided there's an abstract idea, it becomes very difficult to rebut that. However, it is easy to point out that the claim recites something more than just that abstract idea. For example, maybe it uses a particular machine, but not a generic or normal computer. Maybe the claim adds more than typical conventional limitations. Maybe it's a new way to do something, such as in DDR, where it was an inventive concept for resolving a particular internet-centric problem. So this comes into play when you're evaluating software inventions and when you're drafting software applications. So if you are an individual that is deciding whether or not an invention should proceed to the step of an application, or if you're someone who drafts software applications, then there are a few questions you might want to ask yourself as you're looking at the invention. Now, it is our belief that you should focus on the significantly more or something more prong aspect of prong 2. And it's important that there be support in the specification in order to prevent or to provide support for a response to an office action, as I mentioned just a moment ago. So for example, in DDR, the solution overcame a problem specifically arising in the realm of computers. It was an internet-centric problem. So in accordance with a preferred embodiment of the present invention, a specialized improved computer system is created. This is an example of language that might be used to emphasize the fact that this is not a generic computer that I'm using here. This is a specialized computer that results from the software that I'm claiming, from the method that I'm claiming. It's almost in a way a marketing pitch. You're essentially telling the examiner all the reasons why your software is improving the functioning of the computer, and when the computer is running that software, it's not a generic computer any longer, it's a specialized computer. And because of that, then arguably there's something more than just the abstract idea to your invention. So some of the questions you might want to ask yourself when evaluating either a software invention or looking at an application is whether or not the method or system is directed to an abstract idea. Now, as we pointed out several times, this is a very subjective question because arguably it's very easy for someone to look at a claim and identify an abstract idea in that claim. So if that is the case, then the PTO or a court can almost always answer this question with a yes. Accordingly, this probably shouldn't be the filter that you use when deciding whether or not to proceed to an application or whether or not your application will succeed. Rather, I would argue that the next step is the filtering point. Now, another question to ask is whether the computer implemented method is simply solving a problem that has a known real-life equivalent. So, for example, comparing stock market prices has been something that's been done for decades. And if you come up with a computer implemented method that compares stock market prices, then probably that's not going to be patent eligible. The PTO will determine that that's an abstract idea, and unless you are somehow satisfying the something more prong here, then you're probably going to have 101 rejection issues. Another question might be, does the method overcome a problem specifically arising in computers? Now, DDR was a great case because it was an internet-centric problem. This is not an issue that was arising in the real-life equivalent. When people go into a store, they're not seeing advertising that draws them away from the store. Whereas when you're navigating to a web page, you'll easily see advertising that can navigate you away from that web page. Now, hence the problem, I would argue, of an abstract idea identification. I could arguably say, for example, that the concept of retaining customers is an abstract idea. It's something that's been around for a long time. And that's extremely high level, and arguably the claims of DDR were not directed to that abstract idea. But if I were an examiner and I identified retaining customers as the abstract idea, then automatically it would proceed to the next step of the process, which is the something more prong. As another example of whether the method is specifically arising in the realm of computers is an example of improving network speed using a novel data packaging method. So if you were to claim something like this, you would want to provide support in the specification, for example, as to how this is improving the network speed, what are the benefits of improving the network speed, and anything you can do to emphasize that as a result of this, we have an issue that's specifically arising in this realm, and it's improving that network speed. In which case, it's likely going to be patent eligible. Another question is does the method improve the functioning of a computer? Does it make the computer perform something faster, more efficient? And this is what we saw with the PTO example that we looked at just a few minutes ago. Again, if so, then it's probably going to be patent eligible. So some tips for drafting or reviewing an application is it's very important to provide support in the specification that you can rely on if in fact there is a 101 rejection. Now hopefully if you provide that support in the specification, you won't get that 101 rejection in the first place. However, if you do get that 101 rejection, you want to be able to point to an argument that finds support in the specification where, for example, your computer is not a generic computer anymore. It's a specialized computer because of the software, because of the method. Or this is a problem that's only arising in the realm of computers, for example, or only in the internet-centric world. And if there is that support in the specification, you'll be able to rely on that. This is, although this is in a way a drafting, a way to get around the 101 rejection by drafting, it's essentially just pointing to extra support in the specification for this patent eligibility. So as just one example, so for example, if we have a method of fragmenting here, we can say something in the specification like the method significantly improves processor speed by fragmenting the data prior to analysis. And therefore, rather than being a generic computer, a computer implementing this method is highly specialized. Not only is it specialized, it's able to process nearly twice as much data in the same amount of time. So here we have lots of reasons as to why these claims of this particular patent should be patent eligible. And this would be something you could absolutely point to if you were to get that 101 rejection, for example.
Thanks, Blaine. So we decided to give a real-life example here, and this is one of my, I think both of our favorite applications in the App Store. It's called Shazam, and we'll go over the functionality of this application in the next couple of slides. So let's say you're in a store and you hear music from an artist that you thought you knew, but you just can't remember the name of the song. So you start the app by just tapping on the app, and what happens is a digital fingerprint of the audio. Your iPhone starts to collect and capture a digital fingerprint of the song, and within seconds it's sent to Shazam's database and matched with the song that's stored in the database in Shazam's database, which has millions of song tracks and TV shows. You're then given the name of the track by the application and the artist and information such as lyrics, music videos, artist biography, concert tickets, and recommended tracks. You can also buy the song or the album that the song is on. And the owner of Shazam has a family of patents covering the application and the various functionality of the application, which is, again, like many of these computer or software-related patents, the functionality is determined by particular software. So that raises the question here. Blaine and I, speaking for Blaine too, we believe that this application is genius. In fact, it's outstanding. Any time that I'm in a store such as Starbucks, for example, and they're always playing certain tracks that I may be interested in, I flip up the app and it goes right to Shazam and tells me the name of the song. And I've been wanting for years to be able to do that, and it's just a fantastic app. So here is one of the figures of U.S. Patent number 7346512, and it's directed to the functionality of some of Shazam's software that controls its application. The question is, are the claims directed to an abstract idea? Now, I know we don't have the claims here, but basically what these embodiments in this patent are directed to, just what I briefly described, where the application on the phone captures a sample, whether it's a sample song or a sample clip from a TV show, and that information is fed or sent wirelessly to Shazam's database. A match is made, and then down at 22 you can see locate winning ID. That winning ID is sent back to your phone, and it tells you the name of the song. So really what's going on here is there is a capturing of information, a storing of information in a database, a comparison step, and then a generation of a response or an answer. Speaking about it at that, a 40,000-foot view, I think a court would certainly say that there's an abstract idea. There's nothing spectacular about a comparing step, for example, or a capturing step, or transmitting of information between computers. That's been done forever. So do the claims add something more? I'm not really sure in this patent, and that's a question that needs to be answered, even though we may think that this application offers something genius, which again I think it does. it's another question for a patent office either during examination or re-examination or a court to answer. So, thank you.